before he gets back here, I'll just kind of continue where I left off there on, the trust and estate planning. Um, probate protection is really important. And I really didn't even understand any of this stuff. My dad passed away 4 years ago, and I was the executor on his estate. He had thought that he had moved his assets into a trust. He had, paid for a service offline and, paid an attorney to like sign it, but he never assigned any of the assets that he had into the trust. He never created trust accounts. Luckily, me and my brother are pretty amicable, and we were able to sort through everything. But, I've only got one child currently, so also wouldn't be a big deal. But if you've got, two, three, four kids, maybe you've been remarried and you've got, stepchildren, things can get really messy. Unfortunately, when money shows up and it's a large amount of money, people get sideways on things. And I get that, right? Like they're looking out for their own interests. There may be some disagreements between people in the family. Ideally, if you have a family office, you're cultivating continuity and you're having annual meetings and everybody's on the same page and working together, rowing in the same direction. But, sometimes that's not the case. And unfortunately, there are a lot of situations where really a lot of wealth is dismantled and lost, passing to the next gen because planning wasn't done, people weren't proactive, and the people that are inheriting that wealth fight over it. They will go through probate court. And sometimes, a lot of the things that you would have hoped that would have gone to a certain person because of sentimental values or your relationship with them goes to somebody else and might get sold off. So, family heirlooms, different things like that, different types of investments. If you want some control over that, I would highly recommend at least a living trust in your state with an assignment. You got to make sure you assign the assets over there. And that's a lot of what we're going to talk about today. We've had a lot of people with confusion about that. They get the trust set up through Laughlin with us, and then they're like, okay, cool, now what? And so we're actually going to roll out a product here, a templatized version, just like we do with the operating agreement, on the assignment of your, LLC interest over to the trust. We do not practice law, just so people know. We're kind of an architect or design person for your estate planning. But at the end of the day, you're still going to seek legal counsel in your state, especially for a living trust, because that's where it's going to be filed. We're also good to help with the crypto portion in the LLC. But if you want to move your house, your cars, your toys, your family heirlooms, your gold and silver, other things into that structure, you're likely going to want to, again, work with an attorney there in your state to make that happen. There we go. I don't know if you can turn this. It's okay if you don't get the camera. At least I can see you now.
You can see me?
Well, I can see your photo.
Okay. Yeah, I'm not sure what's going on that you can't
Okay.
see.
Well, this will be fine. So, I've kind of laid the groundwork here for everybody and kind of set you up. I've talked you up, hopefully. People have a better understanding of what the webinar is about, but I'll go ahead and let you get into, some of the specifics around the assignment and then, maybe the more complex components of this transfer.
Okay. One of the first things I think that we need to start with is just cutting through the clutter. A lot of times people don't even understand, they know that they need some sort of a trust, but they're not sure what kind of a trust they need. Is it revocable? Is it irrevocable? Jake says that there's 39. Somebody else says that there's 45. In actuality, there is an infinite number of trusts because everybody's trust is going to be a little bit different. There are two basic categories, irrevocable and revocable. And what we're going to be talking about today is the revocable trust, also known as a revocable living trust, also known as a living trust. So a lot of times the terminology is what confuses people because they don't understand that all of those things that we just described, a living trust, a revocable trust, and a revocable living trust are all exactly the same animal. Just like a trust is basically a contract with the grantor, the trustee, and the beneficiary. And you'll hear people say, well, grantor, I've heard of a settlor, but not a grantor. Or I've heard of a trustor. Well, a grantor, a settlor, and a trustor are all exactly the same ones. Unfortunately, we don't have the camera because I was going to switch hats here. I have three different hats for you visual learners. Sometimes you're wearing the hat of the grantor. Sometimes you're wearing the hat of the trustee, and sometimes you're wearing the hat of the beneficiary. Beneficiary is my favorite hat. So
I think it's most people's favorite hat.
absolutely. Mine's got a Beaver Creek logo on it, so that's what I was. You can just imagine that's what I'm wearing right now. But a living trust is essentially the way that property becomes retitled after it becomes untitled because of someone's death. Okay, so if we don't do that during our lifetime, if we don't retitle the assets that we have in our sole name, then what happens is we have to go through a process called probate. And probate is the judicial process by which title becomes vested in the heirs of the decedent, the person that died. Does that make sense?
Mm-hmm. I think so.
Okay, so what we want to do is we want to transfer title during our lifetime so that we don't have the delays, the publicity, the cost. Typically, probate can run in a high tax state anywhere between 5 to 8% of the gross value of the estate. I used to live in Hawaii, and one of the intricacies there is that they really are talking about the gross estate. So if you had a $2 million house and you had $1.5 million worth of mortgage, your equity was only 500,000. What do you think was included in the gross estate? The full.
Yeah, 2 million.
So the expenses of having to go through probate are sometimes just enormous, and we definitely want to avoid that if at all possible. When we're talking about what we do with our LLCs, it is doubly important because of the protections that we get in Wyoming. Okay, so we have a Wyoming LLC, which allows us to have economic benefits and membership benefits. So those are sort of distinguished, and the Wyoming LLC Act distinguishes between those economic rights and the membership rights. So by default, assigning an interest only transfers the economic rights. Okay, that's the beauty of it, because if somebody gets a judgment against you, they don't get to become a member. All they get are the economic rights. Okay, that can also be a tremendous benefit because they cannot book themselves distributions. They only get whatever is distributed for out of the LLC. Now, that's important because if you have taxable income, because they're disregarded entities, what happens is it flows through from the entity to the taxpayer individually. So let's say that we have $1 million worth of income. Somebody gets a judgment against us, and they're going to take, let's say, 50% of our membership interest to satisfy their judgment. Well, they can't vote themselves a distribution, but they still have to report the income. So they get phantom income for $500,000 on no distribution. So
That's not good.
In almost no cases does somebody want to come after you because of that. Now, the other thing that this allows us to do, the beauty of this is, excuse me, the beauty of this is that we have to go through specific hoops in order to admit an additional member. Okay, so both the LLC Act and our operating agreement, which most of our members have used our specialized LLC operating agreement, makes it clear that without unanimous consent, no new member can be admitted. Okay, so that also created a little bit of a problem. That when I was going through this, I thought, well, how are we doing the assignments? And a lot of times you go to an attorney and they'll just draft a simple assignment of the interest, but that's not sufficient. You have to include in that assignment the specific language that admits the LLC, or excuse me, the living trust to as a member of the LLC. So that's why it's so important that you cross the T's, you dot the I's, and you make it so that it accomplishes exactly what your purpose is.
Yeah. If and you're working with other legal counsel, again, we're not the only people that do this, but at least you're going to know again what to ask them and what to look for when you're having those conversations. Um, on that side of things, I think you did a great job explaining what a trust is, why it matters for probate, what the LLC is, why the creditor protection exists there. Um, Over the duration, let's say somebody wants to buy more digital assets or move things in, are they the trustee on this trust?
They are the trustee. So as I mentioned at the outset, a lot of times there are different hats, and those hats are worn by different people. That's why I was going to switch them out to you could see that I'm one guy, but I'm wearing three different hats. In my particular LLC, I was the grantor. Okay, in yours, you're the excuse me, the living trust. You're the grantor, so you are the creator of that living trust. The trustee is who manages the assets of the trust during lifetime. And at death, then there's a successor trustee. And then the beneficiary is the one that gets either the current benefit from the income and the production of different benefits inside the LLC, and ultimately who gets the assets from that. So what we're doing is we're transferring all of those jobs from our from ourselves to ourselves as either the grantor, as the trustee, or as the beneficiary.
Can you be all three?
You can be all three.
Okay.
Now, that's not the case in an irrevocable trust, and we've talked about. That's for a different seminar. But yes, you can be all of those things. And typically, when we're creating the living trust, you are all of those. You're the creator. You're the grantor. You are the trustee. So you're dealing with the day-to-day operations of the trust. You're making the decisions as to how things are going to be invested, and you're also the beneficiary because all of the income that is generated flows through to you. It's a disregarded entity, so it flows through to you on your regular 1040. So you're all of those.
And holding it inside the LLC, you could pay yourself a salary out of that for managing the assets. Whereas if it was just a trust, would you be able to pay yourself a salary?
No, you would be able to take distributions, but it wouldn't be a salary. So
Okay.
you would not have the benefit of Social Security and so on.
Medicare, Medicare, yeah.
Exactly.
So, I think this is a powerful combination. I think there's a lot of people that use these mutually exclusive of one another, but we've combined them to get the benefits from both. And some people again will need more complex estate planning if you've got multiple assets or you have other interests, you diversify your portfolio. But I think this is a really good, like, grounded place to start with all of this. We've got lots of questions over here, but I'm sure you probably had a full program of stuff that you wanted to run through. Is there anything else that you think is super relevant before we get into questions from people?
I just think that it's absolutely critical. Number one, I would say everybody, regardless if they're in this group, they need a living trust. Okay, but some people say, well, I don't think that I've got enough. Uh, if you have a little, it's even more important that you have a living trust so that it goes exactly where you want at your death, uh, and that it is protected from those attorney's fees, probate fees. The probate can take a year. So during that entire time, your heirs don't have access to the assets, the income that would flow off of those, and so on. So absolutely want to make the point that everybody, regardless of their situation, if they're in this group, they need to have some form of living trust. As you mentioned, the living trust that we provide is it's adequate. It is a starting point, and it is absolutely great as exactly that, a starting point. As your situation gets more complicated and you have more assets, and we have post price appreciation, a lot of people are going to be going to something a little bit more. It's not anything different. It's still a revocable living trust, but it's going to have different terms and provisions in it so as to take care of those situations. For example, if you've got complex family dynamics, you've got blended families. A lot of folks have blended families now. Children from prior marriages, potential disputes among the heirs, a child or a loved one that has special needs. You know, those issues are not dealt with in our bare bones revocable living trust, but it does do the most important thing, and that is that it avoids probate. However, the important thing here is that in order to avoid probate, it has to be funded. Okay, funding means transferring the assets. So transferring your LLC, transferring your crypto if it's not inside an LLC, and or your other assets. All of those have to be actually transferred in. Sometimes it's by beneficiary designation that they get in there. Sometimes it's via your will. If you didn't get everything in during your lifetime, what happens is the pour over will says, I'm going to bundle all those things together, run it through probate, and then dump it into the revocable living trust. Because the revocable living trust is the dispositive agreement. That's how your assets are disposed of at your death. And you've given the trustee specific instructions as to how to distribute those assets at your death. Now, when, excuse me, when you die, obviously you're no longer the trustee. So you've provided in that agreement for a successor trustee that puts on that trustee hat and takes care of those responsibilities once you're gone.
Yeah. Uh-oh. Messed up. Messed something up. Hopefully he'll come back up here. Okay. We can still hear him. So in probate, like what's the downside to probate, Dan? Let's say, somebody does end up going, there he is. He does end up going through probate. If there's a public record of all of those assets, even in a pour over will, like you said, you're going to have to run those through probate. Would those then become public record that are now listed?
Yeah, anything that goes through probate is going to be subject to publicity, and it's going to be recorded because you have to file what's called an inventory with the probate court. So that's why the assignment of the assets into the trust, and it could be real estate, it could be your home, it could be bare digital assets. So your actual tokens you could assign to your revocable living trust in the instance where you didn't have an LLC.
Yeah. Well, so to your point, even if you have a little, if you think it could become a lot later, it makes a lot of sense to just at least get that piece in place. Again, we think both is a really powerful combination, but not everybody has the money for both. And the LLC is specific to your digital assets, whereas a living trust could be for the broader scope of your assets. If you have homes, cars, vacation homes, toys, family heirlooms, all those things.
Exactly. Yeah, to the extent that you can, you should get everything titled into your living trust, unless you also have an irrevocable trust where we're trying to jump over the estate tax fence. Then you might have two or more trusts. You could have, an irrevocable life insurance trust. You can have uh, a domestic asset protection trust. So
An islet. Yeah.
yeah, a lot of different trust uh, potentials, but the base document is that revocable living trust, because that's where everything initially needs to go, unless, like I said, you've already got an irrev, and we're working on that.
Yeah. So I think we can kind of run through the questions here for the last 30 minutes. The first one, and maybe we can just outline this process. He says, I have the LLC, I have living trust. What's the process to fund the LLC into the trust?
Okay. We have created a specific LLC assignment that is uh, works perfectly for Wyoming LLCs because of the LLC law and the operating agreement. So it both assigns the membership and the economic interest into the living trust, and then is the title is changed with DWP or whoever else you got, and then we've got a consent of the member that also goes in there, so that it's sort of a belt and suspenders approach. We've made sure that we have documented the fact that we have assigned both the membership interest and the economic interest properly to that LLC, so that there's no question as to who owns the trust when something happens to you.
There you go. And I believe we have a link that we're going to share with people. If you want that documentation, I think moving forward, we're going to charge around 500 for it. That'll be part of the package with the trust that we set up for most people. But for you guys, we're going to provide a discount code of a couple $100 so that we can make sure, because we have a lot of people that have already done this. And, we were concerned. We're like, I don't think they actually assigned it over here and did this the right way. And so that's why we've put this together for people, and we'll be packaging it moving forward, just, make it streamlined and easy
Yep.
for everybody. Um, so this is the same question over and over again for the most part here in the chat. Looks like, everybody's just asking how to get it over there. All Wyoming. So this person says, why have I heard there's a difference in a living and irrevocable trust? So you mentioned that a little bit earlier. A revocable trust, you can change things throughout your lifetime, and you can wear all three hats. But if you had, because I know there's living trusts that are irrevocable, can you talk to the difference as what those are, and then why somebody would use one or the other?
Well, typically, your revocable living trust becomes irrevocable
Okay.
at okay, and there are different variations. It depends. Typical lawyer, it depends on what state you live in. Texas, where you and I are, it's a community property state. There are 9 community property states, and so in those states, a lot of folks will do a joint living trust, and in fact, you can do a joint living trust in non-community property states as well. So the basic difference between an irrevocable trust and when you would want to use that is when your estate is at or going to be over the $30 million for a joint couple unified credit. That's lifetime and death tax credit. So if you know that you're going to have more assets than that post price appreciation, then you may want to create an irrevocable trust during your lifetime, transfer the interest in either your LLCs or other crypto assets that you have directly into that irrevocable trust, while the value of those assets is low, because you've only got 15 million per person, 30 million for a couple. Post-price appreciation, I think an awful lot of folks that are in this group are going to be north of that. And so what we're trying to do now with the IRREVs that we're putting together is jump over that tax fence. The revocable trust, in most cases, those assets are going to, I think you mentioned it earlier in the insurance seminar that you had earlier this morning. Those are going to receive a step up in basis. They're going to be included in your gross taxable estate. And to the extent that it's under $15 million, then you're going to be able to get a step up in basis so you don't have the capital gains. So there's always a give and take, and ebb and flow of balancing what you want to put in your revocable trust versus what you want to have in your irrevocable trust.
Yeah. And we're at the highest amount that's ever been here in the U.S. this year in 2026. I think, while Trump remains in office, that may continue to extend to the upside. But that could change at any time. If Biden had won, he was planning on moving it down pretty substantially. So, if we do have a change in administration, you may want to do this sooner than later, especially, if assets appreciate. Maybe there's a step between where we are now and where I really think it's going. That's probably a good time to do that. And the best time to do it is now if you believe that there's going to be an exponential move. So,
yeah, in terms of what the value was, it was going to go back all the way to, I think, $7 million. I've been in this long enough that it was $600,000 at one point.
Wow.
So actually $150,000 if I'm being honest.
Well, I said 45 years. Was I off? Did I short you anything?
This year will be 46.
There you go. On that, what's the cost difference? Because I know people are going to ask that, right? And really, kind of, what's the time that you should be looking at the irrevocable trust versus some of just the LLC and the revocable trust?
Well, it depends on who you're using. An irrevocable, whether it's an ILET or a intentionally defective grantor trust or a
Spendthrift or dynasty trust. I mean, there's lots of flavors, like you said.
There are, and you're going to be $20,000 to $25,000, probably $20,000 at a minimum, to have that drafted and gone through, and the T's crossed and the I's dotted, and the exploration of what you're trying to accomplish, and so on. The deal with that we've got with Laughlin right now, I couldn't believe it was as inexpensive as it is. Yeah. Nobody touches that. You can't go out retail and have anybody do a revocable living trust for $500. Once you go into a little more complicated situation, a revocable living trust package typically is going to run you $6,000 to $7,000 if you're going to a practicing attorney. Again, it depends on what state you're in, what the particular market, and so on. But you get what you pay for in a lot of these cases. So this is not something that you want to try and get a bargain for. We don't want the cheapest bidder putting the stuff on the space shuttle.
Yeah. Well, and there are a lot of people out there that charge a fair price for things that still don't understand digital assets and the provisions that need to be put in there in order to make that work the right way with the laws and regulations and ongoing, right? And I think that's this is a living document.
Yeah.
Over time, it needs to be revised. What frequency do you think people should revisit this to make sure it's up to date?
Well, anytime you have a life change situation, you have a new child, you move different states. Now, if you get a revocable living trust drafted in one state, it's going to be valid in another state. But that's still a time that you should be looking at least reviewing your documents. If you have a life change, you have a marriage, you have a divorce, you have a death in the family, a lot of times those will prompt a review and sometimes a revision. If you have a major economic event like maybe price appreciation, that's
Probably a good time.
yeah, that's something that you're going to definitely want to look at. And like you said, if there's steps, if it doesn't go from $1.90 to $10,000, well, there may be some steps in there. And when it goes to 10, when it goes to 100, when it goes to 1,000, those are probably switches that are flipped that say, hey, maybe I need to take another look at this. Do I need to be transferring assets? Do I need to be creating some of these other entities? If you decide to use the Rockefeller method and you're going to do some insurance planning, sometimes you can start with, as you said, a convertible term, and later on you're going to convert that to some sort of a permanent policy. There are rules regarding transferring existing policies into uh, uh, trust that we have to deal with. But those are definitely events that you're going to want to say, hey, I need to look at this. I need to get some advice. I need to get in with the proper professionals that know both estate planning and digital assets.
100%. There's three good questions here that people have. I mean, all questions are good questions, but they're kind of basic, and so, but I think everybody has them. So the first one is, do we file the trusts on their behalf? Like working with Laughlin, they file it in the state, or do they need to contact an attorney in their state to get it done?
It's a trust is not filed.
Okay.
It is a private document. It is a private contract between you as the grantor, somebody as the trustee, and you can have someone other than yourself as the trustee, and the beneficiary. So it's a contract. It does not need to be filed.
But it does have an EIN.
Not a
Revocable.
trust. Yeah, it is a pass-through entity,
Got it.
just LLC. Now, your LLC, you may get an EIN, but with a revocable living trust, no, you do not get a new EIN. You're using yours, and that's
Got it.
even if you have a joint living trust where you and your spouse create it. Uh, One question that I don't know if it's come up, but I'm going to answer it here anyway, and that is, can you have a joint revocable living trust that is the owner of the LLC? And the answer is yes. The the trust is a disregarded entity, even if it was created by joint owners, husband and wife. So a lot of times, we're saying, oh, you need to just do a single member LLC. Well, if you've got a joint living trust, it's sort of a way around that. You include the spouse, but you still got a single member, and everything flows through both levels as a disregarded entity.
I think that's the way most people should do it, unless you live in a state where your qualified joint venture exemption exists, which is 15 of them. The other question that I think a lot of people probably have is, can you have more than one trust?
Typically, you don't have more than one revocable living trust, but it is certainly possible. Let's say that you had completely different beneficiaries that you wanted to uh, benefit ultimately. The terms were going to be completely different. Normally, that can all be taken care of in one revocable living trust, but it's not going to be taken care of in our $500 living trust. So, and it's very possible that in cases of multiple marriages,
Right.
then husband and wife are going to have their own trust. They're going to create their own, and one spouse benefits her kids, one his kids, sometimes his, hers, and ours.
Right. Well, so yeah, I think, if you do, like you said, you had a blended family, maybe you got kids from a previous marriage, um, probably want two separate trusts in some of those circumstances. Not always, right? But might be a little more amicable when things are distributed, if it's that way.
Yeah.
This person asks, are trusts state specific? Does it matter where I live if I'm using Laughlin to create the revocable trust?
Well, the trust that Laughlin creates are state specific. So yes, it does matter, and uh, Laughlin will be able to create those trusts in all states except Louisiana. So Louisiana is still French civil law in large part, and they
Okay.
create those. Uh, I actually had that question just the other day, and I gave the member a link to a Louisiana attorney to handle that for her.
Okay. So we have a connection there, for that one exemption.
Yeah.
Um, this person says, which email should they use to set up the living trust?
Uh,
I don't think it matters. I
okay.
think you could, just as long as you can get to that email when you need to. I would expect.
Yeah.
Um, let's see here. Um, Still need to get in front of a lawyer. So to have this executed like beyond, you could execute this yourself, right? We're
Well,
providing you with the architecture and the template and the design. But
yeah,
if you wanted additional legal services to add other things to this living trust, you would want to seek out counsel in your state.
absolutely. And in order in most states, it is going to require witnesses and a notary, at least for the pour over will portion of it. And so typically you print it off and you take it down to um,
The
UPS store,
bank. Yeah.
the bank, someplace that's got a notary, and you need to take witnesses that are disinterested. So you can't take your kids to witness your will and trust because they're hopefully going to be the beneficiaries.
If they're
So
not, that would work, I guess.
yeah, I suppose it.
That would be cruel. Um, Another one of the good. This is a good question. Is this a taxable event? So, like moving it into a revocable living trust, if you're moving that LLC interest in there, based on what I'm thinking, because it's a flow through entity and it's disregarded, it would be the same as a single member when you move the assets in there. There would still be no tax implications or change in basis or time frame.
Absolutely correct. It's a grantor trust, which means that it is a disregarded entity. There is no tax consequence. You can put assets in, take them out. There is absolutely no tax consequence to transactions in your revocable living trust.
Why not? This is probably a good time for the disclaimer.
Yeah,
Nothing
that
here is legal advice. It's only for entertainment and educational purposes. And if you do need legal advice, we would ask that you seek out an attorney. We're here to educate you, provide you context, make sure you have the right questions to ask. And again, the templates and stuff that we provide are not actual legal advice, even though they are drafted by a very good previous attorney that we work with, named Dan. Uh,
yeah, it's just a template,
yeah.
and self-help, just like any other self-help legal site. They don't practice law. We don't practice law, but we have enough information and experience that we're going to be giving you a pretty good template.
Yeah. So it says where are we supposed to type the questions, but they typed the question in the chat. That's pretty good. This person says, I have crypto LLC created with Laughlin. I have someone working on a complex irrevocable trust for me, but I want to have more access to my profits and I'd like to be able to make changes. So I'd like to put together a living trust in addition to that. Who at Laughlin would I reach out to for a wonderful deal you're offering to put together a revocable living trust? So you could just go to our website at digitalfamilyoffice.io. And I believe there's a trust package there. Again, I think it's $500 today, but we're going to move that up to 1,000. We're going to give you guys a discount code that'll provide you, a couple $100 off. So I think if you paid for the whole thing, it'd be $800 with the assignment and all of that. And then, I like both. And to Dan's point, you probably want to keep a portion of these assets in your taxable estate. You're getting the creditor protection through the LLC, probate protection through this living trust, and the other portion would go into the irrevocable trust or structure that you set up. which will be for your children. And you want that to compound over your lifetime to continue to grow and benefit them. But you want access to the stuff that you want. For me, I'm kind of 50-50 on that stuff. There's a large portion that I've moved out of my taxable estate, but there's a portion that I've kept in because I do want control and access to it. But I still want some of those protections that you're going to get. For a revocable living trust, do you get creditor protection if it's a loan by itself, Dan?
You do not. It
Okay.
is. It's just like you own it. I mean, it's what you've the principal purpose of doing the revocable living trust is probate avoidance, okay, privacy, and cost savings. From probate, you're going to save. So privacy.
That's not publicly documented, and just efficiency, and also like control. You know where the assets are going to go.
Right. As I mentioned, it is your base dispositive agreement. It's going to tell people or tell the trustee how you want your assets distributed when you're no longer here. So it may be wife, if you've got a spouse for life, and then to your kids, and you could say, I want it held until they're 25, 30, and 35, or 50, 60, and 70 if you want.
Yeah. So here is this trust formation service. Again, you can add this on if you do the LLC, but a person had asked, where to find that. So I'm going to put that over here in the chat. Type answer. There's the link there for you guys if you want to go to the website. So many of you maybe already have the LLC set up. We've been doing those for years. But if you wanted this in addition to that, that's there. And then you'll get a follow-up link for the assignment with the discount code via email after this webinar, along with the webinar to go back through everything. DWP is $1,000 to onboard. That's a separate service. It's the wealth management side. So that's a good point. Like, let's say your assets are at Anchorage inside the LLC. You're going to have a beneficiary on that account. The assets should go to that beneficiary, and you would want to have the same person listed in the trust, or like which one supersedes the other in that situation?
Well, the beneficiary designation is effective for certain assets, but it does not change the LLC. So once we do the assignment, that needs to be forwarded, and we will do this internally to DWP, and they will put such and such person as trustee of the Dan Plaskett Living Trust. Okay, so that will actually change. The beneficiary designation is used on some of those DWP accounts. For example, the qualified money accounts. Okay.
IRAs and 401ks and those.
Correct. That's why you got beneficiary designations on those, because those you do not change the ownership.
Could you list your living trust as the beneficiary on those individual retirement accounts?
You can.
There you go.
The problem there is that the law changed a couple of years ago, and it still has to be paid out within either a 5
years.
Period of. So a lot of times what you'll do is make the beneficiary designation your kids, and then they can stretch it for 10 years, as opposed to if your living trust says that it's going to be distributed outright, then they would have an immediate taxable event for the entire amount there, instead of them being the direct beneficiary of the IRA or.
Would that be part of their? So let's say that was part of the $30 million in their taxable estate that was passed to you. That's part of their lifetime exemption. You would then get the step up in basis for those assets in that qualified account when it passed to the trust and to the beneficiaries. Or would it be a taxable event?
It's going to be, if it's a traditional IRA rollover, it's still going to be income in respect of a decedent. So you're still ordinary income tax. If it's a Roth, then they are going to be able to get that Roth treatment for 10 years.
Oh, that's great. Yeah. So Roths are great. You're limited on what you can put in there, but if you're going to get substantial upside in crypto, and again, these are all tools, right? And you probably, if you are serious about the asset class and your long-term wealth, you're probably using multiple of these. It's not just like it's an either or. One of the questions over here in the chat was, if it's all going to be, um, appreciated anyway, like why not move it all into the irrevocable trust? And again, kind of comes back to just control over it. If you do the irrevocable trust, you're going to have a trust protector, you're going to have a distribution trustee. There's just going to be a lot more hurdles in order to be able to get access to that money over your lifetime.
Right. You should be using all of the different tools. As you've said many times, and I have too, if all you've got is a hammer, everything looks like a nail.
Yeah.
But
we want the full tool belt over here for people to make sure that you got everything at your disposal. We're coming down to the end of it here. We've had a lot of really good questions. I'm sorry I've been kind of selective on these. We have 259 comments in the question box over here. So I'm trying to get to the ones that I think are going to be kind of across the board for people. Anything that we haven't covered that you think is a normal question people ask?
I think probably the question that I get the most is how do I determine when I should go from a revocable living trust to some form of irrevocable trust? And typical lawyer answer, it depends.
Yeah.
It just depends on what your lifestyle is, what your age is. I've got Roth IRA, but mine's I'm old enough that I can
enjoy it. Yeah.
Yeah. And when price appreciation comes, I've got a way to be able to pull those assets out with no tax consequence whatsoever. Somebody that's 34,
a little different
to do that. But again, like you said, there's no time like the present. The best time to put a revocable living trust in place is yesterday. The second best is today.
Yeah. This person's asked about rental properties inside of the living trust. Can you use 1031 exchange? Again, with it being a disregarded entity and pass through with no EIN, I would expect that all the same rules would still apply.
They do
for tax benefits. Okay.
And you can have, because your LLC in most cases is also a disregarded entity, you could have your real property inside your LLC, inside your revocable living trust.
This lady here has mentioned that she already has a revocable living trust in her state. Would she just need, we obviously don't need to set that up for her. She would just need the assignment if she's set up the LLC to make sure that those assets and that equity is represented there.
Correct. And I think we're offering that assignment as a standalone.
Yeah, standalone. Yeah. And again, we'll provide you guys with the discount code and the follow-up email along with this webinar and the recording. Trying to see if there's anything looming or outstanding here. Does this include Puerto Rico? It's a U.S. territory.
I'm going to say I don't know.
Yeah, we hadn't asked on that one. Virgin Islands and Puerto Rico or something we haven't asked Laughlin on, but I bet they have, kind of like the Louisiana deal. I bet they have an attorney in that jurisdiction they could refer you out to.
Yeah. As far as I know, the last time I looked at it, it was 49. Well, it also was District of Columbia, so 50 territory or states and the district, not Louisiana, and I don't recall any territories, Guam, Virgin Islands, and so on being included in that package.
Here's the website here for people that are asking over there in the chat. Again, I put the link there for you, but you can just go to digitalfamilyoffice.io, go to the services page, and then this is one of the options there. And then I'm sure we'll get you guys the link for the assignment component. What about you, Dan? What if somebody, has more complex estate planning and, they want to have a conversation with somebody like yourself in order to get that going? Where's the best way to reach out to you?
Uh, Through the digital family office. I
Okay.
just go at digital family office and ask for a meeting. I think uh, I've been so overwhelmed here lately.
Yeah.
I think we may have to start charging for some of those consults. But
Yeah.
uh,
If,
you
so
know,
just email the info at, is that the best way? Just say, hey, saw the webinar with Dan. I think I want to do the irrevocable trust, something that's a little more complex. Again, it's more expensive, $25,000 to get that done the right way. Does that include the trustee for the first year?
does.
Okay.
Yeah.
So that's kind of an end-to-end price target there for people. And again, you just email info@digitalfamilyoffice.io and ask for Dan Plaskett. I'm sure you're probably going to have some emails coming your way, Dan.
The last
Um,
I did the carbon two call, I was out in California, and my new granddaughter, and my inbox filled up within hours.
yeah. We also have Christina Carter and a few other people that we work with on this stuff. So don't hesitate to reach out. We would love to help you if this, if it's interesting, if you think you need it. Again, we just want you guys to be informed, educated, and be able to ask the right questions when you are ready for this stuff. Because as assets appreciate, it's definitely something that I think most people will need. Even if you sell, you're going to buy other assets and do other things with that money, and you want it structured the right way to protect it and grow it for future generations and the legacy that you want to leave. Anything, final thoughts as we wrap up here, Dan?
Well, as you mentioned, the time is now. I would rather be 6 months too early than 5 minutes too late.
Yeah.
So, if you're confident that price appreciation is gonna take place, I'm all in. Been all in. Uh,
That's the other thing about Dan is he's part of the XRP army.
so I think consider it. It's always a cost benefit analysis that you got to go through, but the benefit, especially of the IRREVs. I mean, I think the living trust is important for everybody. Everybody should be doing that, but the IRREV, it's going to provide a huge amount of value in the right circumstances.
Yeah. Cost to benefit, I kind of recommend people start looking at that when they have, somewhere between 500,000 and 1 million in their portfolio for digital assets today, maybe even less than that if you think price is going to escalate faster. And if you don't do that, we still have options. It's not like it's the end of the world. We're going to have insurance products. And then Dan and I did a full podcast on the philanthropic component of what that looks like. You're going to be a philanthropist one way or another. If you're over that gift tax threshold, it's either going to be donating it to the government through taxes or putting it to work through private foundations and other things we mentioned there. So if you haven't seen that, I'd recommend going to check that out on the YouTube channel. With that, we'll wrap it up. Thank you guys for taking time out of your afternoon. Come hang out with us and learn a little bit. Hopefully this was valuable for you. Again, you will receive an email with the follow-up, the links and the other things. If you have any questions, please reach out to us. info@digitalfamilyoffice.io. Hopefully you guys have a wonderful evening, a wonderful week, and we'll see you on the next one.